do that. All right, David, it's all yours. Finally.
Mr. Chair, David Broadwell, Assistant City Attorney. What's your pleasure for me to give a quick overview of the entire ordinance and the time remaining to us?
Yeah, why don't we do that?
Okay, and have folks hold their questions maybe so I can get through it?
Right. And then refer to what you have circulated as well. Everybody have a copy? Yep. Okay.
And we prepared a corrected version today. I don't know if Gretchen Williams was able to get you the corrected version.
The one that has highlighted at the top that says corrected is the latest. You did receive one on Friday afternoon, but this one is the greatest and latest.
We have extra copies here for anybody.
Yellow. You got extra copies? Okay. Let me take it.
And, okay, let me, in the interest of time, I'm just going to launch into it, okay?
You bet. Let's go.
Okay, and let me just say for the members of the audience that we are going to do this very publicly and transparently. The draft we're circulating will be posted on the web, correct, Gretchen?
Correct.
And anybody will be able to have access to it and see what we're talking about. It's marked preliminary draft because it has a long way to go. This is a foundation to start the discussion, start the ball rolling. At the last meeting last month, I distributed a lengthy document of decision points, various specific, detailed decisions that the council needed to make to get us from here to an actual licensing ordinance. What's happened since last month, we had 2 meetings of a drafting subcommittee consisting of Councilman Brown, Councilwoman Sussman, Councilman Nevitt, and Councilman Herndon, who then went through the decision points and gave me drafting direction, not always unanimous, that has resulted in the draft that's in front of you. Okay, another quick point is that even though the agenda shows this being an ordinance discussion at this point, we envision there will actually be at least 3 ordinances coming out of the process. The only one before you today is the licensing ordinance. We anticipate there may be a second taxation and budget type ordinance. There may be, subject to further discussion. And then the third will be some sort of a criminal law type ordinance to modify Denver's existing criminal laws on things like public consumption to the extent that you all feel a need to do that. So look forward this summer to talking about all kind of 3 distinct buckets of issues in 3 ordinances. All we're going to talk about in the next few minutes is introduce you to the very first preliminary draft of the licensing ordinance based on the direction I've gotten so far. So I'm going to go through quickly and highlight the way some of those decision points are answered so far in this draft, subject to further discussion and debate by you all. The first biggie is on the bottom of page 2, transition provision. I think that was a great discussion earlier about the difference in a moratorium and a transition. And the transition concept that's contained in this ordinance is allowing state licensing of retail marijuana in Denver, but only for only in terms of swap out or adding to existing medical. Okay, and that's the key concept we've got going on here. And I'll just say right off the bat, the major difference between this draft and House Bill 1317 is this issue of how long that time period will be. And you see repeatedly through the draft the proposal of January 1, 2016 through 14 through 15. That will be the window of time in which we will only be processing conversions of medical or additions to medical in terms of co-location of retail and medical. I see a question already, Mr. Chair.
And I want to be clear, by the language, it looks like you're only talking about those medical marijuana retail or grow or consumption facilities, consumption products, that are legally licensed, not those that are in sort of this transition period, not returning their inspection card, not because it's really bothering me that I don't have a handle.
That was my next point. Okay.
Oh, okay. Sorry.
The next point is that embedded in the language is the idea that you will have to be fully licensed in good standing to be able to qualify to apply for the conversion or the addition of a retail license. So it directly addresses that concern to make sure that if you want to be in the pool, you have to have wrapped up whatever your medical licensing was before you can convert over to the new retail. Okay. So we absolutely are addressing that, frankly, in a couple of different ways. I'll get to a point at the end of the presentation about that. But here's some very important points for everybody to listen to carefully. During the conversion period, if you go over to page 3, you'll see a couple of different concepts reflected that are going to be subject to further debate. You've heard us mention co-location. This ordinance specifically contemplates that co-location will be allowed both during the transition period and long term, that we're going to allow both kinds of licenses to exist in the same location. State law gives you the ability to prohibit it, but nowhere in this draft is a prohibition of co-location. Just the opposite. It contemplates that we will allow co-location both in the transition and long term. Then two other key points on page 3. One is that there will be the ability for the pool of existing medical licensees to have changes of ownership or changes of location during the transition period. So some who would complain that no new entities can get into the business during the transition period, they can by buying out an existing medical and then converting to retail or adding a retail. So there's a safety valve where, yeah, you have this constricted transition period, but there's some give in it in terms of allowing change of ownership and change of location. Of course, any change of location during the interim period would have to be subject to all of our various location restrictions that are set forth later in the bill. But this is something that when time allows, we're going to want to debate this. The bottom line on what I just said is, think of it this way. There's a closed system of a finite number of medical licensees, once they get fully licensed, medical licensees, which it can be no more than that, but there can be some moving around of the pieces inside the box, inside that closed system. There can't be more for the time being, but the pieces can move, both in terms of ownership and location.
Yes, Judy.
One more point, based on the comments that we heard today that I think were significant about some neighborhoods being impacted, having more liquor stores and or, in this case, the marijuana outlets. How recently have we seen a count per council district or locational map, and could we get that as part of our study of that issue?
We have that.
How
That
recent
include
is
all the
it?
new ones, is what
Yeah.
you're asking.
Oh.
We can get a map. Yeah, Tom, you want to?
Sure, we'll talk
You
to
can-
you right away.
Okay, great, thank you. Yep, Peggy.
So we talked about these people who are grandfathered, right? So what are we going to do with them when you say that you have to be fully licensed?
Yes,
I mean, are
we've
you
addressed
gonna
that.
give them-
David's going to,
Okay.
that's coming
Okay,
up.
that's fine.
We certainly have hit this issue. We're very sensitive to it, like all issues.
Okay, next highlighted issue I'd want to call to your attention. Turn over to page 4, lines 13 through 19. This is the issue we talked about last month, where we're proposing in this ordinance to say Denver is only licensing and regulating in addition to a state license, not in lieu of. And this sentence basically says you can't legally operate in Denver unless you have a state license. We've talked at length about how Amendment 64 has all this default language in it about how if the state fails to act on this or fails to act on that, then you can scurry to your local government instead. And we're saying we're not going to be open for business on that game. We're not going to regulate and license in lieu of the state, only in addition to the state. And I have the language in the sentence because it's the intent of this article that no retail establishment may lawfully exist in Denver absent the issuance of a state license and full regulatory oversight of the establishment by the state as well as the city. We want the state to be backing us up in terms of oversight and regulatory resources and not be left to our own devices. So we're saying we're not going to be the default. We're only going to be in addition to the state as an important policy principle under this ordinance.
Yes, Judy? Question.
Thank you, Mr. Chair. So that is a very key point because the state was allowing us to do so. Could you repeat again? They
Yes.
were allowing for us to be able to license.
Amendment 64 itself expressly addresses several scenarios in which if the state doesn't act, you can go to your local government instead and get a license. And we're saying we are not choosing to do that. We're only choosing to regulate in addition to the state, not in lieu of the state.
The state blows it, we're not in.
And we're communicating that out to the world. And that's why we're rooting for them to get the regulations adopted, to meet the October 1 deadline, to meet their 90-day deadline, and so on and so forth in terms of them fully doing what the law requires them to do.
Because if they don't meet their deadline, we can't meet ours in many respects.
Well, a key thing that we've talked about is this idea that they have you look at the list of rules and regulations and all the various detailed things they're telling us in state law that they're going to be looking after. These computer systems, seed to sale, the adulteration and licensing and packaging and so on and so forth. We will not be mobilized and staffed up to do all of that unless there's a state army of regulators actually deployed to look after those things. And so if they were to blow it in terms of any of their obligations under the law, maybe we come back and have another conversation at that point. Maybe we would want to independently regulate, but we don't want to step into that trap, inadvertently, if the state were to miss one of its deadlines.
Well, you heard her. She promised July 1. Today's June 3rd. No wonder they left early.
Okay, ready?
Get back to work.
Next issue.
No, I'm serious. Quite serious. That's a lot to do.
Got work to do, no question.
Are you ready?
Yeah.
Okay. Turn over to page 5, line 12. This is an issue we're introducing in the licensing ordinance, but it will probably show up again in the criminal law ordinance we're talking about bringing back as well. And here's how we choose to approach this issue. We're talking about basically what's legal and illegal in this section. It shall be unlawful for any person to engage in any form of business or commerce involving cultivation, processing, etc., of marijuana other than those forms of businesses and commerce that are expressly contemplated by Section 16 of Article 18. So I hope that's clear. This is a way of drafting to say whatever inventive or creative different kind of marijuana business somebody might be able to conceive of ain't in play. The only things that are in play are the 4 things that the voters were told that Amendment 64 was going to involve, and that's manufacturing, cultivation, retail, and laboratories. There's no room in that language for some other kind of business model. And we're talking about the co-ops, and we're talking about the smoking clubs, and things that I couldn't even conceive that somebody's going to invent next month. This is a way to draft and say the only kind of business for money involving marijuana that we're going to entertain in Denver are the ones that are expressly contemplated by the Constitution and endorsed by the voters last year. Okay, turn over to page 6. And this is a new concept we haven't talked about yet, so I want you to highlight this for future discussion. And I just did a very tentative check with Mr. Downey on this when we met last week. We're thinking of an approach where you all know the bit about how all licensing will start with the state under this system. They will receive applications at their level starting October 1 and then kick them down to us. And we're introducing this idea here of we'll do a 2-part review in excise and license when the state kicks down the license. One, we'll just do a basic locational review. Is the location proposed allowed by zoning and our location restrictions? Okay, and if it isn't, in the unlikely event it isn't, because I hope nobody will bother to apply at the state for something that's patently illegal in Denver, but if it isn't, we'll quickly kick it back. We'll quickly kick it back, express our disapproval so that nobody has to go any further with conditional licensing or whatever else the state might otherwise be doing.
Debbie has a quick question, Dave.
But let me just finish the thought.
Okay,
after the first screening, if we determine that it appears to be in play, then we will go about a local licensing process. At that point, we'll tell the state that it's hanging fire. We're going to go through our licensing process, and we'll get back to you on the ultimate outcome of that at a future date.
Great. Okay, Deb.
So, David, I just want to clarify whether or not any of the conversations that have been had include a business being able to do something like deliveries, and whether an ancillary business like Speedy would be able to ever be. So I'm just wanting to know if that was part of the conversation, and if not, is that a provision we can put in here that explicitly says not allowed?
State law requires all sales on the licensed premises.
Okay.
This ordinance also underscores that. It says all sales on the licensed premises, no such thing as off-site delivery.
So no mobile food trucks at Red Rocks.
Somebody asked me a question the other day about farmers markets, and I said, no, I don't know. It's going to be on a regulated licensed premises under state and local law. Okay, jumping ahead now, and there are other details you might want to come back and talk about, but some of this is borrowed. The Veterans-Owned Council will recognize some of this language now from the medical ordinance that's been copied to some degree in whole cloth and brought over into this proposal. Look on page 8, starting at line 8. Okay, and we're going to talk about quickly 2 big points about the retail stores, the actual retail storefronts. And the prohibited location language and the spacing language, I'll just tell you this is where we're starting, and I know Councilman Lopez wants to talk about this a lot more, but we're starting with essentially borrowing from whole cloth what we did for medical in terms of the spacing requirements, in terms of no residential neighborhoods, we've got, as you can see here after line 8, some enumerated MS and MX zone districts where we have prohibited medical, and likewise we're going to be prohibiting the retail as well. One thing to note down in subsection 3 there on page 8, that we're going to take the traditional spacing requirement that we had from medical center to medical center and apply it equally to retail as applied to both other retail and medical centers. Okay, I get to translate that. The 1,000-foot spacing that will apply to the retail stores will be 1,000 feet from other retail stores and 1,000 feet from medical centers as well. Okay, so that's a wrinkle in here that isn't in the old. But this is a huge issue, which is we're also carrying forward the grandfathering that we originally did in 2009 and carried forward in our subsequent licensing ordinance, which is that those locations which got on the ground quickly in 2009 remain eligible for licensing even if they're too close to each other, and that's eligible for licensing both as medical and as retail or co-located, right? That the grandfathering in terms of exemption from the spacing requirement that we initially adopted 4 years ago still carries forward in this ordinance in terms of available locations.
Chris? Just one caveat is the the proximity prohibition to schools. We allowed for grandfathering in our medical marijuana. We're just making that
absolute.
Right. The U.S. Attorney kind of took care of that business, and we're locking it into place.
That's a great point. Originally, we allowed grandfathering of marijuana dispensaries close to schools, but now it's zero tolerance as a result of the signal sent by the U.S. Attorney last year.
Jean?
So I'm assuming one of the reasons for retaining the grandfathering of retail establishments within 1,000 feet of each other is how would you know which one to shut down?
Yeah. How would you?
I mean, I'm just trying to figure out your reasoning on that because we've heard some of our colleagues say there are too many and too close. And
why would you drive somebody?
I think that's subject to more discussion, but
okay,
virtually
we'll get back to it.
Any grandfathering discussion is the idea that there's been investment made in an existing location, and you allow people to have the benefit of their their investment and continue to thrive. Of course, if an existing location wants to add a retail, they're going to have a process to go through, and that's one of the big points we're going to talk about in just a moment. On page 9, just a quick point, page 9, line 16, signs and advertising. This looks very similar to what you adopted just last year in terms of signs and advertising for medical. There are a couple of tweaks, but I won't spend time on that right now. Okay, major issue on page 10. Page 10, starting at line 12. Here's where you have the only place in the ordinance we impose a hearing requirement on licensing for retail marijuana. Only for the stores, make a note of that, only for the stores, not for cultivation, manufacturing, or laboratories, only for the stores. Now, the rationale there is that that's true of liquor, that kind of public neighborhood process only exists for retail storefronts, not for the other precursors, the manufacturers and in the liquor side of the world, and that's what is being proposed here by the drafting committee. That's obviously subject to further discussion. The other thing, I'll complete the point and see if there's questions about this. The other thing reflected in this paragraph is a process that looks a lot like liquor in terms of posting and notification and so on and so forth. A lot of the language you see on page 10 and 11 is very, very similar to the liquor code in terms of what a retail marijuana store would have to go through. But here's the absolute most important thing. If we have a hearing process, go to page 11, down to line 34. For purposes of this subsection F, the term good cause, what would be good cause for denial of a retail marijuana store license? This is really where the rubber meets the road, and I've told you all that you can have a hearing process, but that's not the point. Hearing for what purpose? What are the criteria for actually denying somebody, right? And here's where the draft in front of you departs from the liquor code in a significant way. It doesn't use the term reasonable requirements of the neighborhood, needs and desires of the adult inhabitants. That's not reflected in this draft at this point. It's fairly bare bones, frankly, in terms of what it says. So beginning at the bottom of page 11, basically the hearing is about people producing testimony about whether the proposed business is in compliance with applicable state and city laws, most of which will be state laws about premises and so on and so forth. State laws and regulations will define most of this. That's basically all subparagraph 1 says. You flip over to the next page, and here's a couple of interesting ones, and that is another criteria could be whether or not if it's a proposed retail center that is owned in common with a bunch of others, and bear in mind that unlike liquor stores, the new state state retail marijuana code allows multiple ownerships. You can be one owner and have a bunch of different shops, right? Liquor stores, you can only own one, but the single owner can own multiple shops. This would be a criteria that says if you do own multiples, then we could take a closer look at your application to see if you're cornering the market or engaging in restraint of trade or whatever by taking over this neighborhood or whatever the case may be. That also is a provision that appears in the liquor code under H&R licenses, hotel and restaurant, which, you can have as many restaurants as you want, but that's a criteria that can be looked at in liquor licensing for some kinds of liquor licenses. I borrowed it and inserted it here for your consideration. And then finally, the criteria of if the proposed location of the license is a place where there's been a medical center, you can look at their history as a licensee to see if the medical center has caused problems in the neighborhood as one of the criteria that folks could come and testify about. They want to convert or they want to add a retail. Well, if they've been causing problems in the neighborhood, that would be competent evidence for people to come forward and talk about at the hearing and try to convince the director to deny the license. So that's all I'm going to say about criteria. I need help here. This is where you all as policymakers can really play an important role and say, what do you think would be appropriate criteria to be, if we're going to have licensing hearings at all, what would be appropriate criteria to have in front of the hearing officer and the director of excise and licenses?
Jeannie?
Why did you not put needs and desires in there?
That was the will of the drafting subcommittee at this point.
Just into discussion.
Right. Absolutely. Anything else on that point?
Well, the point is, even the mayor did not use the term needs and desires. He advocated input from the neighborhood, but he specifically avoided the term needs and desires in his letter. Jeannie?
I know we'll have time to debate it further. My only question in terms of substance right now on the needs and desires, I can understand why the subcommittee and the drafting committee would take this approach for the conversion of medical marijuana to recreational. But when we change in 2016 and other recreational marijuana facilities can come in, needs and desires might be more appropriate. And so a question I would have is, does this preclude that coming up then? Would we have to change legislation at that point?
It doesn't preclude it.
Anything, yeah.
But would we have to pass another ordinance?
Correct.
Yeah.
Debbie?
I just asked Tom about language pertaining to, somebody with a felony that is applying. Can you just speak to that and that's covered in these provisions?
Right. There are a number of places in the draft bill where rather than reinventing the wheel by copying a lot of the same verbiage used in state law, we just says in accordance with state standards. So, but it's certainly, remember, the state law allows you to adopt stricter criteria if you choose to. Right now, this is fairly bare bones, and you said what the state standards are. Councilman Nevitt referred to this earlier. What the state standards are is what we're adopting by reference, and they have character standards, residency standards, and so on and so forth. But if you wanted to add something in addition, and let me use this as an opportunity to return very quickly to the co-location issue again. When I asked the question I asked of them, and what I heard was, we're going to have a rule by the first, but it could change. If you all are worried about the details of how co-location will work, then you need to give me direction, and we can legislate what we want to see, to the extent we're allowing co-location, and not depend upon state rules being the be-all and end-all of that subject. Now, what I would hope is that they effectively come up with something definitive so we don't have to draft for it. But if we're nervous enough about that or any number of other details, we can legislate for it.
Yes, Judy, and then
Thank you. This question is for Tom Downey. I don't know if you've already seen this draft. So I was just wondering, would you, or do you already have ideas for a process should this go forward? For example, posting on buildings and things like that when there's a license that's being applied for?
It's all in there.
It is? Where is it?
I think it's in the other end. It's right. There's all this.
Okay.
All this gibberish.
Yes,
Tom Downing with Excise and Licenses. Yes, I was part of the discussion.
Okay.
And we will take direction. We'll figure out, we'll take whatever the policies are from the decision makers, and we'll figure out the logistics as best we can. But we'll comply with whatever the posting requirements, notice requirements are that you create.
Thank you.
oh, Albus, I'm sorry.
Yeah. Just a quick question, you, David, on any kind of, when the state is enforcing and has any kind of violation on a certain MMJ shop, as the rules are today, how do they enforce that? So if there's any kind of violations.
The first and foremost tool is yanking your license.
Okay.
You can suspend a license. You can impose fines in lieu of suspension, very much like the liquor code, or you can revoke a license outright.
In the hearing, can we have, if any fines have been placed on certain businesses, can that information be placed forward to the neighborhood so that they are aware of that? And to, most importantly, to excise and license?
You're asking if anything has happened historically, like to this date?
Yeah, just to...
Well, I don't believe anything like that has ever happened, but
Okay.
But yeah, we could find that information. There's nothing in this law that assigns to anybody the responsibility to gather information on state licensing activities and share it with neighborhoods.
Yeah.
If you wanted to mandate that on an executive branch agency, we'd have to write it in somehow. But
I just want to make
doable.
sure. I just want to make sure people are coming to the table. Excise and license probably has some knowledge. The director does, but the neighborhoods who are coming to the table, that they are fully aware of the history of a certain business. That's all.
Here, Chris?
Just a quick, Philip. The background check for owners and operators is really important, and this is a case of one of the belt and suspenders components of what we drafted here as a first draft. We, as people issuing the license, will rely on the state's background check, but if we don't think it's good enough, we've explicitly authorized the Director of Excise and License to do his own. If the state's doing their job, great. We'll go with what they got. If we don't think the state's doing their job, Tom Downey can do his own.
It's another little.
Yeah.
Yeah, okay. We're going to go to 5:15, guys. Okay, you got 5 more minutes, David?
Sure. The next several pages on cultivation and manufacturing, once again, are borrowed a lot from the medical marijuana side of the world in Denver. The thing I mainly want to emphasize 2 things for you. I'll turn over to page 14. And you see at the top of the page, there are 2 special things that we did for cultivators in 2010, 2011 that are carried forward in this ordinance. And this all relates to, as the veterans will painfully remember, the fact that we were adopting medical marijuana licensing at the same time we were adopting a new zoning code. Okay, and a lot of the locations, or some locations where plant husbandry was allowed under the old code, wasn't allowed under the new code, the zoning code that is. But what we've done is we've grandfathered the old plant husbandry locations, and we're going to carry forward again the grandfathering in this law, but with the same 2 limitations as we talked about a couple of years ago, which is that if you've got medical marijuana or marijuana cultivation occurring in a non-conforming or compliant location that frankly isn't in conformance with the existing zoning code but has been grandfathered, you can keep doing it, but you have a couple of special things that you have to do, and that is whenever you want to renew your cultivation license, you have to go through a hearing process, unique only to this one category. Renewal of a cultivation license requires a hearing as described at the top of page 14, and if there's been problems in the neighborhood with your cultivation operation, your renewal can be denied. Okay? But absolute hearing required in all cases. And then over on page 15, there's another wrinkle that If you're a cultivator in a non-conforming location, there are restrictions on your ability to change ownership of that versus having to shut down when you change ownership. And I won't go into detail. That all starts on page 15 at line 17. This was part of a compromise that occurred a couple of years ago where there was some move at that point to just get rid of the non-conforming locations, but no, we're going to allow them, but put them under extra scrutiny. Again, that concept is carried forward in this ordinance. Turn over to page 16, and you'll see several issues hanging fire in the middle of the page there. One is that we still need to spell out, and this goes a little bit to the Councilman Brooks's question a moment ago, the civil penalties and licensing sanctions. I still need to add a section on that. Frankly, I was looking to see a little bit more about what the state was going to do in their rulemaking to get a sense for what their hammers are going to be, and maybe model off of some of that. The drafting committee, just off the top of their, not off the top of their heads, after reasoned consideration, is suggesting a $5,000 annual operating fee as being what we would charge. Bear in mind, application fees at the state level, we get shared 1/2 of that per the Constitution. But there's some restrictions in 64 in terms of our ability to have our own application fees. There is some leeway for us to have something called an operating fee that we would charge to licensees on an annual basis. And this is a number that we're putting out there for consideration by the group. I think over the next couple of months we're going to have a lot more discussion about what the fees will actually translate into in terms of enforcement resources of our own, setting aside that money and devoting it to help excise and licenses keep on top of this whole industry as it continues to evolve.
And this represents a $3,000 increase. It's currently $2,000.
Over the minute.
Well,
Yeah.
2,000.
it's more complicated than that. Go ahead, Tom.
Well,
Currently, it's $2,000 for the application fee, $3,000 for the annual fee.
Okay,
The application fee will be governed, as David said, by Amendment 64. The proposed annual license fee would be $5,000, a $2,000 increase over medical marijuana.
And then, if you will, turn over to the last paragraph on the last page, on page 17. And this gets back to the issue we touched on earlier. The issue of pipeline applications that have been hanging fire for years. Because they're able to lawfully stay in business even if they don't have a license, as long as they're in the pipeline. And we're saying no mas, at last, no mas. At least as of, we'll give you another year. We'll give you till July 1 of 2014. But this goes back, this would be an amendment to our original medical marijuana licensing ordinance where we gave that tolerance, just like the state did, but say there has to come a judgment day if you have not. If you want to stay just in the medical business, you don't want a new retail license, but even just to stay in the medical business, you have a drop-dead date where you have to be fully licensed or else you're going to be illegal on and after that date. We talked about a closer date, but frankly, unfortunately, there are just so many yet still in the pipeline that both in terms of dealing with the new licensing trafficking under the new law and helping some of the long-standing pipeline applications under the old law to get current, it's going to require some work and some heavy lifting in excise and license to get it all done. So that's very quick, just a few key highlights and a lot more discussion to come.
any other questions?
Just one
Chris?
detail. So if you want to stay in the medical biz exactly as you are currently operating, you have until July 1 of 2014. If you want to add adult use retail or you want to convert to adult use retail, you must, before you pursue that process, you must be all licensed up before you can make that move.
There's both a
for those
carrot.
who want to make that move,
There's a carrot and a stick in this ordinance to address the
do that sooner. You
backlog.
can't
All right,
move to retail before
All
you
right.
get your license.
David, thank you. Remind my colleagues this is first draft.
I'm sorry, Mr. Chair.
Sure.
Yeah, and let me be clear about this, is that this is the result of the initial drafting.
Right.
We're putting it out to the world, and we invite people on all sides of the issue to
We
take a
will
look
hear.
at this, comment on it, and get us comments. We haven't even circulated it internally yet, so we're going to circulate it to various departments and agencies of the city, and we expect to get a lot of constructive criticism as we go forward.
Thank you to the committee. I remind the subcommittee we are meeting again this week.
Oh, we are? Oh, this is
Subcommittee. And in terms of a general meeting, I'm still having conflicts. It's hard this time of the year to get a good date, but we're still working on it. I'll let you know. We are adjourned.